This morning.
Great.
Ready for some fun?
By fun, you mean stuff that's going to get us more and more confused and ticked off? Then yep.
It is my fondest wish, and in fact, I fall asleep at night dreaming of wanting to tick you off and confuse you. It's what I live for. Anything on your mind?
I have a question about more procedurally than anything, but if somebody is on trial, having to face two trials, and they get convicted in the first one, suddenly, is it possible for them to make a plea deal to avoid the second trial altogether?
Is it possible what?
To make a plea deal to avoid the second trial altogether.
Sure. I mean, you can, and there's still a lot of leverage at that point. Now, there's less leverage because pre the first trial, the leverage the prosecution has is, and for the reason that I want to reach a deal, is to avoid both trials. And at that point, you can't avoid the first trial anymore. But there's still sentencing on the first conviction. So if you reach a deal, you not only avoid the second trial and whatever charges are coming up with that, but you may get the prosecution to agree to make a favorable recommendation as to sentencing in the first trial. So there's still a lot to negotiate over, or at least there could be, depending on the circumstances, and depending on whether the prosecutors are the same in both cases. A lot of times you'll have a situation in which there are different prosecutors involved. One might be a federal, might be a state prosecution, might be different jurisdictions within a state, depending on how far and wide your crime spree was. So you may have a situation in which you don't want to bargain with one prosecutor unless you know the other one is going to be on board with whatever deal is reached. So, but if there's coordination, there can often be a lot of reason for both sides to be willing to do so, depending on what they're getting out of the deal. I mean, the first prosecutor in the first case may not have any reason to want to negotiate at that point because they've won their case. But if they do have some reason in terms of getting cooperation, or if they're also the prosecutor in the second case, it could be very good reason for them to negotiate. So yes, Steve. Okay. Anything else? Okay. Let's talk about Twitchell. And here we have a mistake of law situation in a particularly tragic context. Tell me about David and Ginger Twitchell and what happened to their family.
So they were members of a Christian or silent Christian church who in healing by spiritual treatment,
Right.
as opposed to conventional medical care. And when their son became ill with
This is Robin, who's less than 3 years old?
yeah,
Okay.
he became ill with peritonitis.
Peritonitis, yeah.
They sought advice from a church official whose name was Talbot, and he was the head of the committee on publication.
And what do we know about this condition? If you were not a Christian Scientist, what do we know about this condition and the outcomes you could expect to have?
It needs to be treated, otherwise
And what if it is treated?
you can survive if it's proper.
It's right. There's routine surgical treatment for this that has an extraordinarily high success rate, and I mean, obviously it's a serious condition, but it would not ordinarily be fatal under these circumstances. But they don't use this surgical treatment, as you said. What do they do instead?
So they consult pretty much a church official who is the head of the committee of publication, and he tells them that he tells parents that if they choose to not treat their child, that they'll be protected under a Massachusetts statute that stated that the child wouldn't be deemed to be neglected or lacking proper medical care just because it was spiritual needs rather than medical needs.
This is 273.
Section 1, a child shall not be deemed, you said neglected or lacking proper physical care, is that it?
Yeah.
Proper physical care solely by reason of what?
That he is being provided remedial treatment by spiritual means alone.
By spiritual means? I want to highlight a couple of things in here. This solely suggests that if you do something else to your child, right, in addition to the spiritual treatment, that it could be a problem, right? If you not only use spiritual treatment to deal with a disease or a condition, but you also starve your child, that can be neglect, right? So if the solely is important, right? So there's the statute saying if the sole basis on which the state might otherwise charge you with neglect or lacking proper physical care, if the sole basis is your use of spiritual treatment, then you may have a defense. By spiritual means alone, right? So if you decide that that's the only thing you're going to do as treatment for your child, and that's the only basis on which the state can say you were neglectful or the child was not properly cared for, that isn't enough. That is not enough. Okay? So on what basis did the state, despite their belief that, hey, this statute permits them to choose this course of action, what did the state charge them?
Involuntary manslaughter. Involuntary
manslaughter. And what is the legal requirement? What does the state have to prove to convict them of or anybody else for that matter, of involuntary manslaughter?
They need to prove that it was reckless conduct.
And what is recklessness? What is, go back to our mens reas from way back, or the court gives you to you in this case for what constitutes recklessness. What has to be involved for their conduct to be reckless?
That they had a duty to do so.
It has to be a duty in that. And why does there have to be a duty?
Because they failed to perform it.
It's a failure to perform, which makes it
omission.
It's an omission. And we go back to actus reus. Right? With actus reus, we know that if there was a failure to act, if that's the basis on which the state says there was an act, as there has to be, then there has to have been a duty that you failed to perform. Is there a duty here?
Yes.
Because which duty of the ones we talked about way back when, which duty is involved here?
That they're dealing with their child.
And they are
their
parent. The duty of a parent to care for a child, to get medical care for a child. So there's no doubt we have a duty. So that's not in terms of that's actus reus side of the picture. So that doesn't define what recklessness is, since recklessness is on the mens rea side of the picture. So we do, whoa, that's not going anywhere. We know there has to be a duty because it's an omission or a failure to act. Failure to seek medical treatment, which the state is charging, was the problem. And here, the duty exists as parents. Okay, that's the actus reus side of the picture. What about the mens rea? We said it's recklessness. What does that involve? Unpack that for me, someone. These should be ones you, at some point, you're getting, not necessarily right now, I'm not saying right now, but you should get to the point where you know these, like, you can rattle them off.
High degree of likelihood.
High degree of likelihood.
that substantial harm would result?
In this case, the death of the child. And if you take the risk, you're aware of the risk and you take it anyway, because that differs from knowledge, because knowledge would be
Because you knew that it would that it was a
you
sure
knew
result.
that it would happen. It was virtually certain it would happen, not just that it was a substantial likelihood. And it differs from negligence because
you were unaware that it would result.
so you are aware here, aware of the high degree of likelihood. Whereas negligence is you should have been aware. You weren't. Prosecution, or at least the prosecution doesn't have to show you were aware, but you should have. A reasonable person would have been aware of the risk. Okay? So if recklessness is the mens rea for involuntary manslaughter under this statutory code, and let me pause to note, that will not always be true. Right? Some regimes may define involuntary manslaughter differently. You have to check carefully. You can't assume, oh, involuntary manslaughter is always that. Some regimes don't have involuntary manslaughter. Okay? You have to know what your code requires. This happens to be in Massachusetts, the way their structure, their framework is set up. Okay? So that's involuntary manslaughter in Massachusetts. Okay? Given that framework, why does the court say that, in fact, this 273(1) doesn't provide them a defense? Mr. Ramaswamy?
Because the Committee on Publication misinterpreted the statute.
And how so? That's exactly right. What was wrong about the publication?
It said that they wouldn't be held liable, but they actually were, and they...
Why would they be held? What's the difference, though, in substance between what the Defense 273 does provide and why they can still be charged and convicted, at least potentially, with this crime?
Because of estoppel?
No, that's the second issue. That's the second issue. Ken?
Is it that the statute is referring to neglect of property?
Which is what kind of crime? It covers what kinds of crimes? If you were going to think about a statute that charged you with neglect, what do you think, what kinds of crimes would that be? In general terms, a category of crimes. Crimes of?
Civil?
No.
Omissions?
No.
Torts?
No. But torts are not crimes. That my skin crawls. Negligent crimes. Right? What the court says is 273(1) covers crimes of negligence. And what does the court say about about involuntary manslaughter? It is not a crime of negligence. What did we just say? It's a crime of recklessness. The court says this only protects you if they charge you with being negligent, right? Neglect. Negligent. You can wait to deliver those until after class. Okay? So, so limited protection. The court says 273(1) gives you limited protection, not from something like involuntary manslaughter, because it's a more serious crime. Okay? So they lose, right? Right, Ms. Ramaswamy? They lose. That's the end of case, right? No, it's not the end of the case. Why?
Because
What else do they argue?
they argue that it's not their fault that they were given the wrong, the parents argue that it wasn't their fault that they were given the wrong information from the committee.
And at this point, would I be wrong in reacting and saying, too bad, so sad to them? It's not your fault. And cry me a river.
No.
Would I be wrong? Or the Massachusetts Supreme Court, I'd be wrong.
Yeah, you'd be wrong.
I'd be
If they
wrong.
ended up-
Don't be afraid to tell me I'd be wrong, because often I'm hoping you'll tell me I'm wrong. Okay? Why does the Massachusetts, now, you might feel that the Massachusetts Supreme Court was wrong, and it's totally appropriate that they can be convicted despite their mistake. Why do they say that their mistake, or to what argument is their mistake relevant? What are they arguing? They're arguing that it wouldn't, not only wouldn't be fair, but it goes beyond that.
They argued that since they were relying on that publication, they were entitled to.
Relying on that publication? What is the value? What is the value to them legally? Without more, because there's going to be a more, I promise you, but let's say it was just that, of just a publication from the Christian Science Church in terms of giving them any sort of defense. What is the value when they offer that up? If they just offered the publication and there was nothing behind it, what would be the value on a scale of 0 to 10? 0 being they'd be laughed out of court and sent straight to jail, do not pass go, do not collect $200. 10 being it's an absolute ironclad defense, they're good to go, scot-free. How many people vote for 0? How many people vote for 10? How many people vote for something in between? The answer is -43. Okay? Why does the publication alone give them nothing?
Because it's not a source of law.
Because it's, and it not, what rule does the court state is required for it to have any value? Using, I'll give you a hint, the model penal code as sort of support for the conclusion it reaches.
Was it that it has to be from like a practicing or like a government official?
A government official, give me more, yes.
I know why they accepted it, but I don't.
A government official with,
It's like the model penal code, like, set like 2.04.
right,
So like the proposed draft, and it says like it has, like, so like there's a special merit for the rule of religious beliefs.
And-
Like, it has, like she was saying, it has to come from a, public official.
what, but something more, like in theory, I'm a government official. I work for the government, sort of.
Doesn't it have to come from like the legislator? Like,
No, not a legislator.
Someone charged with enforcing the law.
There you go. Has to be a government official with authority to enforce that law and issue official statements of what they mean. Right? So the fact that it comes from, if it was just this publication and they said, well, this is what we think 273 means, so you're good to go, that means nothing. But the Twitchells argue, no, it would violate due process, and that's their argument. Not just that it wasn't fair, but it would violate due process to convict them when they relied, they say, on the official statement of a public official, not just any government official, but one charged with enforcing this law. Who's that, Ms. Rangaswamy? Who's their get-out-of-jail-free card?
The attorney general.
The Attorney General. Because this statement was based on what?
His opinion in the article.
An AG opinion. And in every state of the union, at least as far as I'm aware, this is something Attorney Generals do. They issue opinions on legal questions, controversies, interpretations of statutes, constitutional questions, etc. And those AG opinions can have enormous legal significance. One of the things that it's always at least useful, if not essential to do, is check whether there is an Attorney General opinion on an unsettled question of law, because that will have great impact on how the courts may then rule. Now, they're not controlling necessarily, because the courts have their own say, but that can be really crucial. So here, what the Christian Science folks and then the Twitchells relying on what was in this publication say is there was an Attorney General opinion. And that, to convict us in the face of that Attorney General opinion, which seems to give a broader exemption than just to crimes of negligence, that would violate due process. And how does that argument fare, Ms. Rangaswamy?
So
They end up ruling for the Twitchells, saying that they cannot be held against the advice, or they cannot be convicted based on the advice of what the Committee on Publication said.
And what should have happened below?
It should have been,
Should they just be acquitted, period?
no, they send it for a retrial.
And what should happen, according to the court? How should that unfold?
They said that the jury needs to have new instructions and be advised on the terms of the provision of the statute.
And, Lamb?
The publication needs to be admitted.
Admitted, but in what procedural form? Ms. Richter?
I think the jury has to be instructed to decide whether a reasonable person would conclude from that Attorney General's opinion that it would be interpreted the way.
And how should the jury be told to consider it?
They're allowed to present it as a defense to the
As a defense. Right? That's something you want to keep in mind, is the give and take of the criminal cases. Prosecution presents its side. On any elements of their case, they have to prove it beyond a reasonable doubt. The court here says, no. It's not an affirmative defense for or it's not an element of the case for the prosecution to show that they didn't rely on the Attorney General opinion or that it wasn't reasonable. But if they want to raise it, they have to raise it as an affirmative defense. And then, yes, it's admissible, and the jury should be told that if they find that they relied on the Attorney General opinion and that a reasonable person would have relied on the Attorney General opinion to give a broader defense than simply to crimes of negligence, then they should be acquitted. And then the Supreme Court goes out of its way to give a strong hint that they think the prosecution should just drop this, which is kind of unusual but not unheard of that the court would make that clear. Okay? Questions about the Twitchells, about the basic rule here you want to take away is that while ignorance of the law is no excuse, this case involves something, a twist on that, which is not ignorance, but an affirmative belief based on some source of knowledge that what you did was lawful. And under those circumstances, when you have an affirmative belief, if that belief is based on the official statement of the law issued by an official charged with its interpretation, that can be the basis of at least an affirmative defense.
And so when you're doing an affirmative defense, the bar for that is not beyond a reasonable doubt.
The bar for that is usually preponderance of the evidence. Okay. But it's the defense that has to prove it, right? So if you're the defense, you'd rather have an affirmative defense than nothing, but ideally you want the prosecution to have to prove the flip side of that issue and prove it beyond a reasonable doubt.
Okay.
That in this case, they didn't rely on the Attorney General opinion, or that it was not reasonable, and they have to prove that beyond a reasonable doubt. But if it's an affirmative defense, yeah, at least you make it an issue, so that's good from the defense. The bad news is you have the burden, not to beyond a reasonable doubt, so that's good, but you have the burden.
Okay.
So the difference between this and Cheek is that Cheek's reading of the law was unreasonable, and
The Cheeks, well, for one thing, Cheeks was not even arguably based on an official statement of the law.
yeah, maybe like seminars.
Right.
But that's he had like a reasonable, or these parents had like a reasonable belief because they were coming from an official statement of law, and therefore, and Cheek didn't.
That would certainly be, it's not just that it was reasonable, right? Because a jury could conclude that their belief was reasonable, although the first jury didn't, but a jury could.
And still fine.
But still convict them if it wasn't based on an official statement, right? A jury might decide, look, especially if the instruction said a reasonable Christian Scientist or a reasonable person with those religious beliefs. Because then the jury might say, well, yeah, a reasonable person would think that this statement was a correct statement of the law and they were just mistaken. But that's not good enough. It has to be not only reasonable, but reasonable and based upon a specific category of information.
Well, didn't she act under the advice of the lawyer that was giving the...
Good. And
again, on a scale of 0 to 10, what is the value of relying
on a private attorney that you hire versus relying on an official statement from a government official who has the responsibility and the authority to interpret that law?
I want to say -43 just because it's the number that's stuck.
That's good. No, I wouldn't go that far. I would say like -20. It's better than relying on the publication of your church, because at least it's, and there's one decision, it's mentioned in your notes, it's from Delaware. I can't remember the name of the case, but it's in your notes, in the book, about, and it involved bigamy.